News Radio 700 WLW.
Rock, I remember when I first heard about this, I thought it was a joke. That Ohio State was trying to patent the word "the," as in the Ohio State University.
No, but apparently some smart folks have figured out that's probably very, very valuable, because then you can then put that on a T-shirt, you can put it on a hat, and you can be the only person that can put it on a T-shirt and a hat, and therefore worthwhile. It's a pretty genius. Well, I'll give you an example. You know, for Notre Dame, you got the "Play Like a Champion Today" sign, right? Everyone knows that.
Sure. Yep.
Now, I even went there, right? And I had thought that sign had been hanging there, like Newt Rockney put it up or something, right? No, Lou Holtz put it up in like 1986. Okay,
I did too. I thought the Four Horsemen had run by that
right,
thing.
Exactly. Yeah, like Paul Horning himself.
Right,
But
exactly.
anyway, I guess a group like a whole LLC of Lou Holtz, Rick Meyer, Derek Mays, and a couple other folks patented it like in 2008, and it's like no one thought of that to do that until 2008. You know, so it's I guess it can be fairly profitable.
But the trademark on "the" has been awarded to Ohio State University as of just recently. And we wanted to talk to our good friend. We've had him on many times. Always great. The patent professor, our good friend, John Rizvi. And John, how does something like this work that you can trademark the word "the"?
Yeah, well, I'm getting a lot of calls on this, and for good reason, because just like I heard you guys earlier, like "play like a champion," at least it's got it's a phrase, right? It's not just a single word. Like the might be the most commonly used word in the English language. How can one company own that? And I think it kind of is like a fundamental misunderstanding of trademark law. So when you get a trademark, you're not stopping anybody from using the names. I don't know if you remember, several years ago, Trump applied for "you're fired," and there's this huge uproar because everyone's like, "Oh, what are we supposed to say when we terminate somebody?"
That's when he was doing The Apprentice. Yeah.
Right. But trademarks are for commerce. So if you're selling a product or goods or services, and you're using a specific word, that word can be owned by you as a trademark. It can be your brand, but for that specific product. Like one example is Apple. So, I mean, how can one company own the word Apple? Like people might ask that. Well, they don't, and they do. They own the word Apple when it comes to computers, when it comes to cell phones, electronics. They have a whole slew of classes that they've applied for. But that doesn't mean you have to go to the grocery store, see this nice crispy fruit, and come up with some other, and you can't say it. It doesn't stop speech. You don't have to point and have the salesman say, "I'll have one of those."
Give me that red thing over there, please.
Right. So, but I mean, if you think Ohio State University is I went to the University of Miami, the law school, and the University of Miami has a trademark on a logo for a U. So that's not a word. That's a letter. But again, it's for specific categories, and doesn't give them broad, unfettered infringement access, claims against anybody having the letter U in anything. So it's specifically for certain goods or services. I mean, in the case of the Ohio State University, it's for clothing. So anyone selling specifically clothing, T-shirts, baseball caps, hats, things of that nature, the word "the" could be problematic. But if it's by itself. Now, if you have something else on it, then
it doesn't preclude, like, say, like for Father's Day, like your kid gets you a baseball cap with the world's greatest dad on it. That's precluded from something like that, right? I'm obviously.
Yeah, absolutely not. There's no confusion. I mean, and a lot of times when you see slogans and drawings and pictures and things on T-shirts, they're not identifying the brand. That's really just an ornamental, decorative part on the front of the T-shirt. Typically, the tag on the back, like where you see like the Fruit of the Loom used to have those tags on the back. Now they have like a sticker so it doesn't, itch your neck or whatever. But that's the brand. That's you'll see a hanging tag, or you'll have something on the back of the T-shirt, around the collar. that's the brand. So the D is used as a brand by the Ohio State University. So so that's different than the world's greatest, somebody putting the world's greatest dad. Just because the word D is on a T-shirt doesn't mean that that consumers are confused and think that it's a brand.
But John, does it preclude some entities from being able to say the Ohio State University, whether it's on television or social media? And I'll give you an example. And I don't know the full details, but I feel like March Madness, like you're not allowed to say that on television, or ESPN, we're not allowed to say it because someone else owns that. So does it preclude, can you patent a phrase and therefore certain entities can't even say it for the benefit of their company?
Yeah, so one of the factors that the trademark office looks at is the importance of a phrase or a brand for competitors to sell something similar. So, the thing is, the more common a term, the less broad protection it's given. So the word D is going to be given extremely low protection because it's just the need for competitors to have to use that as part of their brand is high. But it doesn't, they can't use it by itself and sell T-shirts, caps, or hats. That could be problematic because consumers might believe it's a product put out by the Ohio State University or affiliated somehow with the Ohio State University.
Well, and it's like the Super Bowl. I mean, to go along with Rock, what he said about March Madness, the Super Bowl every year, you hear people talking about, get a pizza for the big game. Because, hey, you're having a Super Bowl party, get a couple of pizzas. Get some pizzas for the big game coming up.
And I assume, John, is that so like the advertisers don't have to pay the NFL the money to say the word licensing? They're advertised to make money off the word Super Bowl?
Yeah, so, you bring up an interesting point. Sometimes for companies, corporations, it's a term that they don't even put forward. It's just the consumers in general start developing a name or a nickname for something. The Volkswagen Beetle is an example. Like, consumers started referring to it as a bug. The company never officially, they didn't start that. That was just what people started calling the car. And then the trademark, they decided afterwards, hey, we better protect this so a competitor doesn't create a vehicle, which seems a little far-fetched, and call it a bug.
Right.
So that's the case. I don't know if the big game is something that started by fans that started referring to the Super Bowl as the big game, or it's something initiated by the NFL. I actually don't remember, but they don't know. But the reality is it doesn't matter. If consumers start associating it and the NFL decides to file for a trademark then and sell specific goods and services, then it very well may be registered and then get protected.
Yeah, it goes back. We're talking to John Rizvi, our pet professor here. And John, it reminds me, and I don't know, Rocky, you probably remember this. Back in the day when the internet was fairly new and people were squatting on possible websites. Let's say that, you were in college and somebody be like, you know what, this guy might become a professional football player. I'm going to squat on RockyBoyman.com, and then you'd have to buy it from him.
That actually has happened, because when I went to put my book out, I wanted to get RockyBoyman.com. Somebody owns that, and I went through an intermediary, went to the person and said, hey, what do I need to get that here? Here's $100. And they said $7,500. We'll start there. And I said, go screw yourself. And so now my website is therockyboyman.com.
So obviously that stuff's still happening.
Yep.
Yeah, so you're right. The early days of the internet, there was really no protection against that. Now there's the Anti-Cyber Squatting Protection Act to prevent that. But it just goes to illustrate that the law is always a little bit behind technology. There's not, in the early days of flying drones, there were no regulations, there's no laws. You could practically fly a drone anywhere, and the laws catch up after the fact when people realize, and start regulating and realize, hey, these things could be dangerous. There could be a public safety could be at stake or whatever. And the same thing with the internet. You're right, people were registering as cyber squatters domain names to trademarks and holding them ransom And a lot of times they were successful just because there was no precedent on how a company could get their name back. They also were registering generic names. I don't know if you remember, there's names like drugstore.com, pizza.com. These domain names were sold for multi-millions of dollars. A lot of times they were registered by kids, like some 18, 20-year-old kid registers drugstore.com because the large, huge multinational corporations didn't wisen up to the possible value that a domain name could have.
Well, yeah, I seem to remember that some of the big car manufacturers had a problem with that. I don't know why. I think Toyota sticks in my brain. I want to say Chevy. I don't remember, but it just seems like several of those guys got caught with their pants down, and they had to pay, like you said, big bucks.
Yep, absolutely. I mean, and it even happens. I don't want to get too much into politics, but I remember, I believe GeorgeBush.com or something with one of the recent elections. Donald Trump registered that domain name. JebBush.com. He registered the domain name before the Bush campaign was able to get it captured. So these things happen. It's critical, to keep abreast of these changes because technology is changing very quickly, and companies have to keep up, or else you could lose huge rights. I mean, right now, the latest land grab, so to speak, is in the metaverse. Like people registering trademarks for use in this second universe, so to speak, that's in cyberspace.
So they're cyber squatting on cyber stuff.
Yeah, absolutely.
That's insane.
This makes my head hurt when talking about that. Like cryptocurrency and all that.
John, that's another conversation altogether. We've kept you too long. Really appreciate you talking to us. John Rizvi, the Patent Professor, thepatentprofessor.com. Thanks so much, man. Always a pleasure.
Same here. Thank you.